The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. 3 cases will be heard this morning. Those cases are DuTrac Community Credit Union and Quick Trip versus Radiology Group Real Estate and others. Second case is Wellmark Inc. Versus Iowa District Court. And the final case is Iowa Supreme Court Attorney Disciplinary Board versus Richard Crotty. The last case is now submitted to the court without an argument and will proceed to hear the arguments in DuTrac. Mr. Arling, excuse me, Ms. Shaff.
Thank you. May it please the court, my name is Martha Shaff, and along with Brandon Loberek, we represent the appellants in this lawsuit. For ease of reference, probably more to me than you, I'm going to refer to us as the landowners. This case arises out of a commercial development in Davenport, Iowa, referred to as Waterford Place. A partnership now dissolved, Cathedral Partners, developed this area. In January of 1996, a restrictive covenant was recorded stating that no building or other structure shall be erected on any lot in this addition without the approval of the Architectural Control Committee, consisting at that time of David Lundy and/or Michael Duffy. This shall be interpreted to include approval of the structure, design, building materials, site plan, landscaping, and signage. In May of 1996, 5 months later, the covenant was amended. The only change was to substitute Dennis Britt for Michael Duffy. Lots were sold, buildings were built, lots were resold. There was no issue until DuTrac attempted to sell one of its lots, or its lot, to Quick Trip. At the time of doing their due diligence for the closing, they discovered that there was a restrictive covenant and requested that the covenant be terminated so that they could build.
Ms. Shaff, could I get a clarification? Is some of this land that was platted, 20 or whatever years ago, is some of it still undeveloped? Is that the situation?
That is true.
And the Quick Trip would be on what is now undeveloped land?
Correct.
Okay.
Correct. They requested that they could build on the lot without a committee approving the structure, the design, the building materials, the site plan, landscaping, or signage. They want to build whatever they want without review, unlike any other building that has been constructed on that land so far. They filed a declaratory judgment action in Scott County. Summary judgment was filed by DuTrac and was granted. The landowners, who I represent, filed this notice of appeal. It's our position that the district court erred in finding that the restrictive covenant could not be modified, in finding the purpose that it did for the restrictive covenant, and for finding that it had a limited time duration. We believe that pursuant to the restatement third of property, which we would encourage this court to adopt, that the duration of that restrictive covenant, absent something specific stating otherwise, is for an unlimited duration. And in this particular case, there was no language in that restrictive covenant that indicated it was to terminate at any particular event.
Well, let's focus on restatement of property, third 710, which is the applicable provision. So it says when a change has taken place, all right, so I assume the change is that neither one of these two individuals is available anymore, the two that were originally
Correct.
Going to be. Since the creation of a servitude, which makes it impossible as a practical matter to accomplish the purpose for which the servitude was created. What is the purpose for which the servitude was created? What do your clients contend was the purpose?
To have architectural overviews such that when someone builds a building that it fits into the commercial landscape of what the other buildings are, so that you don't have, for instance, I mean, you can glean from the names of some of these groups. There's a radiology group, there's a oral surgeon, St. Ambrose has a building, that you don't have a trash
Now,
can.
that leads to my next question, which is, it struck me reading the briefs, there's maybe a disconnect between that purpose and the remedy that you proposed to the district court, which was sort of to just give all the property owners a seat at the table. I mean, it strikes me that if you had a property owner that already has a convenience store, well, they might vote against having another convenience store there. If you had somebody who wanted to open a radiologist's office, then the radiologist might vote against it. That seems different from what was originally set up, which was this kind of review by one or two architects, right?
Well, I don't think that we're proposing that they can shut down a certain type of business. I think the proposal would be that the landowners had the control to at least architecturally review what the building might look like, so that you don't have one place that's, for instance, in a development, you might have a 10-story building and then everybody else is a 1-story building, so that there has to be some review that way. I don't think that we are asking, or that we can ask, that this court direct or that the district court direct that a certain type of business cannot go in, but it could certainly be directed that it fit into the landscape so that they all look similar, because that appears to be the intent of what was done by the original developer.
But following up on
Yes.
Justice Mansfield's question, the enterprise of modifying the original covenant would require not only a determination of who and how many folks might be making these committee decisions, but other determinations, like does the committee have to in approving the proposed construction. So it would be quite a heavy lift to formulate what this committee's going to look like, wouldn't it?
Well, I don't know that it has to be unanimous or that the whole committee has to vote, because when you look at the original covenant, it said and or. It didn't say that both had to approve it. It didn't say that they had to do it together. It said either. It said it said David Lundy and or Dennis Britt. So taking from what was done with the original, it would be, we were trying to propose a proposal that's the fairest. What would seem like the fairest is that you would allow every landowner to have a position on the committee. We can't compel them to be on the committee, but they would have the ability to be on the committee. This is a restrictive covenant that didn't have a great amount of detail, but that seems to be contemplated by the restatement that could happen, because you're not two parties that are getting together and negotiating out the terms. Would it have been a lot easier if it had a lot more definition? Certainly, but I don't think that to ask the court to give direction that each landowner, and 18 doesn't seem that outrageous, could have a spot on the committee if they so choose, seems outrageous. And then excuse me.
Don't know if you finished. I know you haven't finished, but I
That's
just
all
had
right.
another question. I wish we had a little more record about what the history of the development of this area has been. You're saying that at this point there continues to be vacant lots in this area, or obviously 17 other people own these other lots that are in the area. When's the last time we've actually used this architectural committee, I guess, is my question.
That's not in the record, and I don't know that I can answer that. I can tell you that there are vacant lots. But there have obviously been multiple owners. For instance, with the fact that DuTrac has this lot that they're selling to Quick Trip, or attempting to sell to them, that is an undeveloped lot, and obviously DuTrac purchased it from someone other. They're not the original Cathedral partners.
Well, you see where I'm going with this,
Yeah.
is that as part of the briefs as well, there's no language regarding modifications. I assume somebody's maybe had a building on there that they've modified in the last 20 years. I don't know, but have they had to pass that by an architectural committee? And it still goes back to my original question, when's the last time anybody even functioned as this architectural committee?
And it's not in the record, and I don't know the answer to that. I think that the strict reading of the restrictive covenant would not allow architectural review of a modification. It says erection. Now, if you tear down I think there's a solid argument that if you tear down and start over, you're erecting. But if you're repainting the outside or you're changing the outside somehow, that would not be subject to architectural review.
What do we make of the idea that at least half, I guess, pretty close to half the people don't have any interest in even answering the petition for declaratory judgment, so they don't care about the enforcement of it? It doesn't appear to me. I'm just going to make an inference of that. And several other ones have consented to basically waive the declaratory judgment action or waive the condition that's there. What weight do we give to that, if any?
I don't really give any weight to it. I think that there are a couple things we can infer. Number one, only one landowner affirmatively said they agreed with bringing in Quick Trip. St. Ambrose and another withdrew their answers and just said whatever the court does we'll live with. Several defaulted. The reality of the matter is that the entities who have brought this matter have the standing to do it, which will benefit everyone. Now, we can say that they didn't want to spend the attorney fees. We can say that they didn't want to get involved. There are lots of things I think we can infer from the fact that they didn't affirmatively answer the pleading, and only one said, yes, we agree, that's what we want. And that obviously cut off their attorney fees because they said, you know, that's it, and then they never did anything else. So, yeah.
I'd like to focus on the purpose issue. It strikes me that's at the heart of the case. And a land developer who is beginning to, kind of plot out the real estate and so forth and so on, is always concerned at the beginning about restrictive covenants. And they're concerned about restrictive covenants in order to maximize the land developer's ability to market the land. And, if you're doing a development of some kind and you end up with selling off a parcel and you get an oddball use, you got a problem. So land developers at the very get-go worry about restrictive covenants, and the covenants are really for the benefit of the land developer, although arguably they kind of benefit the owners too. And obviously the district court gave some credence to this theory. And I want you to rebut it by, first, what in the record there might be that would say this doesn't fly. And I think your record's kind of shy on that, but I want to get your input. And then second, why is this just wrong?
Well, I think that the purpose, it does benefit the landowners.
Well, let's start with what's in the record to suggest whether the purpose was to promote the land developer's interest or the landowner's interest. Is there anything in the record? No.
I don't think there's anything in the
Okay.
record that supports that it was only for the developer, and I think arguably there isn't any that it supports only the landowners. But reality would say that if you adopt what the district court says, that it's only to benefit the land developer because he's selling off the lots, well, the same thing would apply to the landowners, because if they go to sell their lot, if we've now allowed anything to be built there, part of why they bought there was because of the uniformity. Now their property value arguably could go down because that hasn't been enforced.
But the structure, I'm going to push back just a little bit, and we're just exploring here, but the structure is there's two particular individuals. There's no committee set up. There's two individuals. What do we know about these two individuals that were...
One's the developer, one's an attorney.
You see, and this is suggesting that the developer is having his buddies, quite frankly, or her buddies, sit on the committee so the developer can make sure that it doesn't have some kind of oddball structure come up on his development. And the fact that those two are, I'll call them his or her buddies, is very material to what he's doing. Now, maybe I'm speculating from the record because we don't really know, but what we do know is that they're two specific people. It looks like the fact that it's Lundby and
Britt.
Thank you. It looks like that's a very essential part of the restrictive covenant. No?
I don't think that we can go that far, because obviously when the restrictive covenant was drafted, there were no other owners of the property. And obviously they could have put in a succession plan, but they didn't. And there's nothing under the law that requires them to. And there's nothing under the law that says a restrictive covenant won't be enforced just because you don't have a succession plan. And say Lundy sold one of the lot sells again, do you only have architectural control over the first time he sold it because that maximizes his profit? Or does he get to have architectural control over the subsequent sale too? So that,
Up to Britt and Lundby, my buddies.
well, you could argue that, but I think that the purpose there is to keep control over what it looks like. And so the fact that Lundy's deceased and Britt is unwilling to serve, it doesn't stop the court from modifying. And the restatement of property states that they recognize that these aren't going to be perfect documents. They aren't always going to address all of the issues that can arise. And should it have certainly I might not be here arguing with you today if they had put in that succession plan, but they didn't do that. So it is allowed for this court to address the problem without changing the intent. And that's the reason why we think modification is appropriate, because it would perpetuate the purpose that was set up by the original developer. And as landowners, it's important. Yes.
Following along that same line of inquiry, what about the fact that now we still have Britt, who's still around, but all the lots have been sold now. Apparently the developer's out of the picture, of course. Somebody else owns all these lots. He's already a designated person on here, but he doesn't have, again, by his actions, he's saying, I don't want anything to do with this anymore. I don't want to have any oversight of this. I don't care what's happening architecturally with the property now. Doesn't that lead to a conclusion that perhaps the whole purpose of this was just what Justice Apple was saying, is that as long as we have control over the original sale of all these things, that's all we care about?
My time's up. May I answer your question? It seems to me that we have to make a lot of assumptions to get to that point. We can also assume that Dennis Britt is just at the point in his life where he's like, I don't have the capacity to be involved and I don't want to be involved. And so he doesn't want to jump in. But it doesn't mean that there isn't a purpose. And it's ignoring the landowner's interest in this if we don't look at how the purpose serves them. And I think that landowners have a very vested interest in continuing the restrictive covenant, not just the developer, because of their land values, which is what the developer was concerned about too. So if we assume that just because those two named individuals were the only ones that mattered, then it was a restrictive covenant that gave no benefit to the landowners. And I don't think that's what the restatement of property suggests, or would, I think that's not what they would support. Thank you very much.
Ms. Shaff, thank you as well. Mr. Arling.
Thank you. May it please the court, counsel, it is my privilege to be here this morning on behalf of Quick Trip, Inc., a privately held Wisconsin corporation, and DuTrac Community Credit Union and its member owners. Initially, I want to start out with an idea that we've been talking about moments ago, the court has been talking about moments ago, and what is being the purpose of this covenant. And I find it ironic that had the remaining living member of the Architectural Control Committee wanted to, that member could have approved any build on this lot that member wanted to, and the remaining landowners would have zero control over that, based on the exact verbiage of the restrictive covenant. Now, fortunately for the remaining landowners, Mr. Britt.
By the same token, if he disapproved,
Correct.
you would have been in trouble. Your client would have been in trouble.
Correct.
So where does that lead us?
Where does that lead us is, what I'm getting at is, this is a developer control issue.
You know, I have to say that argument, maybe I see a potential flaw in it. I mean, this is like, it seems to me it's like any planned development. The developer puts in restrictions to enhance the value of the development as a whole and to enhance what he or she can get in return for those properties. But then the people that buy those properties expect to get what they paid for, and what they paid for is a development that's subject to this kind of restriction. So it does strike me that on its face it benefits both the property owners and the developer. And certainly there's a number of property owners that are represented by Ms. Shaff. They think it benefits them, right?
And I don't disagree with that there is there could be some indirect benefit to the remaining property owners. To get the intent of the restrictive covenant, we're bound by the words that are written. There isn't much of a record here. Frankly, there's nothing filed of record other than this restrictive covenant that leads us to understand what was the intent.
And so we need to figure out the purpose with
Correct.
with the kind of a thin record, frankly. But it's not necessarily true that the land developer and the purchasers are in conflict, which is Justice Mansfield's point. I mean, the land developer came up with the restrictive covenants, it seems. I mean, the chronology supports that. But the purpose not only is to protect the land developer, but also to give value to the people who purchase it. It is true that there are no standards and whatever, so it's maybe, arguably, the restrictive covenant is kind of a weak one, or strong one, depending. But a purchaser might buy thinking, well, you know, if some really goofy structure was proposed, I'm confident that these people of experience would say no. And if that was the purpose of it, then the restatement, assuming we adopt it, probably kicks in, right?
Well, perhaps. And I know opposing counsel has argued that we should adopt the restatement third, but I would caution you against just wholeheartedly adopting the restatement third, because that will change the law in Iowa. The law in Iowa is currently, you look at a restrictive covenant and kind of infer it against the person who's trying to enforce it. I mean, there's this idea that we don't want to preclude the free use of land, and that's black letter law in Iowa. So adopting the restatement third, specifically section 4.1 has a comment that says, the rule that servitude should be interpreted to carry out the intent of the parties and the purpose of the intended servitude departs from the often expressed view that servitude should be narrowly construed to favor the free use of land, which is the law in Iowa as it sits now. So I would caution the court to be very careful against just wholeheartedly endorsing the restatement third properties based on servitudes for that reason. It will be a paradigm shift.
Well, I don't know that I necessarily agree with that, because I think you can look at the restatement third for the purpose of guidance. And so a couple of the other elements that they apply as far as restatement is to look at, does it serve any useful purpose any longer? And then also, does it create any unnecessary harm, again, to your client in this case? You know, it gives you some factors to utilize in balancing these things. But I'm going to shift gears a little bit. The one thing that really bothers me, I guess, with the restrictive covenant here is that it runs with the land. And, you know, that's a real term of art when you're dealing with real estate. So if I'm buying a piece of property and it says that this is a protective and restrictive covenant, which shall be a covenant running with the land, to me that has some pretty significant consequences. And I guess when I see that language and I'm a buyer of real estate, I'm saying this is sort of in perpetuity. It's not of limited duration. It runs with the land regardless of who owns it. So I guess I'd like you to respond to that.
Absolutely, thank you. I agree, it does run with the land, and part of our argument here is we don't disagree that it doesn't run with the land, and Quick Trip, as part of their due diligence, as established, for their build. The problem came when the two named individuals, the developer and the developer's friend, as it was put earlier, who was a real estate attorney, neither one of them would approve or disapprove. So going back to Justice Mansfield's comment of, hey, they could have said, no, you're not going to build it. Well, then we would have been done. They could have said you could build it, and we'd be done. Running with the land clearly means that it applies to successor parties until, as we're arguing here, based on impossibility, we can't get the thing done, as they say in the various case laws. The thing cannot be done. Well, the thing in this standpoint is having anybody who's the named party of the Architectural Control Committee make a decision. So you're right, it does run with the land, and it is not infinite, it is indefinite as far as duration, because it doesn't list the duration, although I would argue that based on the language alone of the covenant, it is of limited duration.
Mr. Arling, if the restricted covenant was intended to be only controlled by Lundy and
Mr. Britt.
Britt, or whoever,
Sure.
why did the restricted covenant first say that it was going to be controlled by a committee? Why wouldn't they just say, nothing can be erected unless it's approved by Lundy and Britt?
Well, if we're going to speculate, I'm going to speculate that they wanted something called an architectural control committee, but then when they go on and specifically define what that committee is, in the first one it was architectural control committee consisting of, it was Dave Lundy and Michael Duffy. 5 months later, at a time when Cathedral Properties still owned all of the lots and they had the ability to unilaterally amend these this covenant, can't say these covenants, there's only one, it was amended to say the Architectural Control Committee consisting of. So, to your point, why would we set up the term control, or the Architectural Control Committee and the individuals? I mean, I think they could have called them anything, but the idea is, here's what we're gonna call them, and by the way, they are made up by these two individuals. So it's, if you look at the definition, it's a specific definition, and it only applies to these two individuals. Going back to a comment earlier of, does it provide any benefit to the landowners? I was answering indirectly, perhaps, because they feel that somebody out there will be exercising this control.
But I mean, the fact that there's evidence that at one point in the past, a new committee person was added and one was left, isn't that an indication that there was a body that was a part of this restrictive covenant to control the architecture and not necessarily the individuals?
Respectfully, Your Honor, I would say no. And the reason I say that is, at the time that was changed, it was at a time when the person who could change it owned everything. So I don't think we can read into that. It could be just as likely that Mr. Lundy got at loggerheads with Mr. Duffy for something unrelated to the development. We just don't know. But the idea is, at the time this was initially prepared in January of 1996, it was prepared by the owner of all the lots, and it was that owner, or the partnership is what I'm referring to as the owner, that specifically identified, here's the Architectural Control Committee and here are going to be the members.
I guess we're engaging in a little bit of speculation. Let me offer you mine, Mr. Arling, and tell me if I'm wrong. First of all, even if we can't draw any conclusion from that original substitution, it was still an and/or setup with the two individuals that were put on it in 1996. So there was still at least some provision that if one of them wasn't available or something happened, there would be a second person. So that shows some intent to perpetuate this thing down the road. And then the other speculation I would offer is, in my experience, developers are always incredibly over-optimistic. And I bet this developer in 1996 didn't expect that any of the lots would still be vacant 20 years later. Is that fair speculation?
That may be a fair speculation. And one question asked earlier that was brought up at the district court level, I don't remember if it's in the order. When DuTrac purchased this property, it was with the intent of building. If you're familiar with the area, DuTrac then bought a building, several buildings down, that was already set up, which is why this land has sat vacant. Could that be the speculation? Yeah. Did they think it would still be there this long? No. I would, if we're going to go on the speculation route, which can be fun, I bet you the developer didn't ever anticipate that the developer's opinion would somehow try to be pushed into one vote for each lot owner. As has already been pointed out, I believe, by Justice Zager, we served 17 defendants. I had answers that were filed on behalf of 8, less than 50%. Of those 8, 1 was in favor. Of the 7 remaining, St. Ambrose University then withdrew their answer and consented to what we were requesting. The other one, I can't remember if it was TJ, LLCC, whatever, there was another defendant that, and this was after we disclosed as part of our amended initial disclosures, the affidavit from Dennis Britt, saying, hey, listen, I'm off. I want no part of it. I've effectively resigned. For clarification, I am resigning now. Another defendant withdrew their answer and said, hey, whatever the court wants to do is fine with us.
I mean, under the, what you're suggesting is maybe under Ms. Shaff's solution, you have the votes.
We might have the votes under Ms. Shaff's solution, but my point is Ms. Shaff's solution should not be applied to this case. As the judge ruled, I believe, and we believe the judge appropriately but reviewed and looked at the unambiguous, clear language of the covenant to determine what the intent was, and that the court appropriately determined, based on the doctrine of impossibility, the thing could not be done. And
The problem with I have with what the or may have with what the district judge what the district judge did is I agree that it's unambiguous that that's how the committee is set up, but the very purpose of 7.10 is what do you deal with? When can you modify? So the fact that you're making a modification assumes that you're changing the language that's there, right?
under 710? Yes. So if you're going to modify it, it would assume under 710 that you're going to modify the language. My concern is looking at the intent, and granted, the record, based on time, based on whatever, isn't very robust. But the intent of the developers, based on contract law in Iowa, is what do the words say? And I think if you look at what the words say, they would tend to show the intent was developer control. So if you go to 7.10 and other parts of the restatement third, you have to look at what would an ordinary purchaser anticipate this covenant to mean. So if I'm buying the property, and in this case, we had an ordinary purchaser called Quick Trip buying the property. Their intention was that Mr. Lundy or Mr. Britt would approve or disapprove the planned construction. Their intent clearly, or their thought clearly is not that 18 members would approve that. Going back to, and I apologize, one of you mentioned that perhaps somebody doesn't want another business coming in, or perhaps somebody, for whatever reason, wants to object, you know, whether it's, hey, I already have this business here, I don't want you there. That brings a whole different level to the playing field that under 7.1 would not be practicable. And if it's not practicable, even under the restatement third, you can say terminate.
Now, Mr. Arling, was it Mr. Britt that actually wrote this language?
The covenant language?
Yeah, who was?
We couldn't, all we have is speculation. If you look at the original one from January of '96, the notarization on it was Dennis Britt. Britt was with the firm as Britt, Gorsline, and something else. They had a title plant. We're assuming that he drafted the language. We're also assuming that he probably drafted the amendment 5 months later. When he's a member, obviously he's not notarizing it at that point. But we don't know. He was not able to tell us that we have in the record. So
And Britt was Lundy's attorney.
That's what I'm speculating that, but just based on what's been prepared and what's been added to the record, yes. So it is unfortunate from the standpoint of all the time and effort that somebody who was named to the committee didn't follow through, but as pointed out in our briefs, he has that right. He can withdraw.
Counsel,
Yes.
my recollection is these covenants under Iowa statute have a life of 20 years, and if not refiled, they expire. Is that correct?
That is correct.
Right. So we've passed that 20-year mark, haven't we?
As of right now, yes, I see I'm about out of time. Well, I guess I'm not. We are awfully close up against that. It would be May of 2016 is when it would have expired. Our title search would have been probably a little bit before that based on the timing of this. So I don't know if anyone filed a certification you can file to renew them. At the time, I was not aware of one. So it may just go away on its own.
Who would have authority to do that?
Any landowner in the development.
Okay.
All right. Thank you, counsel.
Thank you.
Rebuttal?
I can address that. I believe it's 21 years, and it will expire if you go by the first restrictive covenant later this month. It has been renewed. The parties to this litigation, the appellants, don't know if all of them signed off on it, but at least most of them signed off and filed with the recorder's office a motion to continue. But it's not in the record because it happened after this was submitted to this court. I think it's important that we distinguish between intent and purpose. I think that purpose is what the restatement of property looks at and what this purpose was, and I don't think that we can speculate that anyone would have known that Dennis Britt would refuse to serve. And because it was a committee, I think that the purpose did not go away just because he refused to serve. As a landowner who purchases the property knowing that they had to submit for approval, you, I think, can make the assumption on this record that they would assume every other owner has to submit for approval as well. So it is not a limited duration restrictive covenant. It is one that had purpose for everyone. And under comment 4.1, it states that searching for a particular meaning adopted by the creating parties is generally inappropriate because the creating parties intended to bind and benefit successors for whom the written record will provide the primary evidence of the servitude's meaning. So if we look at who owns the property now, this clearly benefits them to have the ability to say, we want to look at your plans. We want to have a say in architecturally how you're going to design this building. And while it certainly has created more trouble than it should have by not having more definition to it, that does not mean it's impossible, and that does not mean that it cannot be modified. So we would ask this court to remand this matter to the district court, stating that the purpose was for an unlimited duration, and it was to benefit the landowners, not just the developer. We can't look at this restrictive covenant and jump to the conclusion that it was only going to be a profit-making for Mr. Lundy, and it ended once he sold his lots and made his profit. As a landowner, I think that, you know, you buy a house anymore and the restrictive covenants in many of the neighborhoods, and you assume when you bought there that those restrictive covenants will continue because that's part of the reason why you may have been enticed to buy. So that direction can be given to the court to say that under the restatement of property, which we advocate for this court to adopt, this is a remedy that works. Now, maybe
Gotta change the law. I mean, I'd like you to rebut or respond to the notion of caution in adopting the restatement. You know, plainly, we look to the restatements for whatever instruction there might be. It's not binding on us, and we don't adopt them whole hog. We do it usually section by section. But the suggestion here is that the adoption of the restatement third section that's germane here, A, would be a significant departure from Iowa law, and B, would lead us into the netherworlds of kind of speculative thinking. But why don't you respond, please?
Well, I think that, number one, the last time the court addressed this issue was 1968, and the restatement addresses the fact that in modern day, so to speak, real estate, and that restrictive covenants are becoming much and much more prevalent, and that there is a public policy that approves of them, likes them, and that's the reason why real estate is selling, is because there are these covenants that allow people, developers, to state that this particular area is going to be under these types of architectural reviews or whatever it might be. It might just be no fences, but it's a change in, we have to keep evolving, and the court evolves, and as the public has evolved to have more and more real estate developments, real estate developers are much more sophisticated now than they were 40, almost 50 years ago, and so that it is appropriate for this court to move with what is happening out there in real day. And happening in real day is restrictive covenants are used much more. And because of the fact that it is not a two-party negotiation, you need to look at the restatement of property as our position, because it's not just a contractual issue. So to go back to that 1968 case where they analyzed under contractual reasoning would be wrong for the way these are created and why they're created. So we would advocate that it is the time, and we happen to have the facts that allow the court to adopt the restatement of property. third.
Do you agree that the doctrine of impossibility would make the restrictive covenant unenforceable if it had just identified Lundy as the approving person?
I'm out of time, may I answer? Yeah. Your Honor, I don't believe so, Justice. I believe that your point that you made before was well taken, that he stated an architectural control committee. And so while he named the committee members at that time, it could have easily been drafted to just say David Lundy will have only control. And if it had stated just David Lundy, then the argument, I think, can be made that this is a developer only. But when he states committee, he puts someone else on the committee, then I don't think we can read it that narrowly.
Well,
And of course, it calls
was it
for-
really a committee?
Well,
Said Lundy and/or Britt?
well, and I guess that we don't know. Yeah, I mean,
Does that sound like a committee when you say either this person or that person?
well, I think the argument can be made that it was a committee that was being started, and here are the founding members of the committee. Now, he didn't detail what was going to happen into the future, but it doesn't rule out the possibility that there can be others added. Thank you very much.
Thank you as well. DuTrac is now then submitted to the court, and we'll next hear the arguments in Wellmark.